Okay, here we are. It's 2:02. Thank you all for joining. I'm Michael Ettinger from Ettinger Law Firm, and this is the first of a six-part series, what we call our Zoomside chats. And this came out of COVID, actually, when we were giving seminars. I started giving seminars when I was 36 years old, and I gave them until I was for over 30 years. I gave over 5,000 seminars, and then it kind of stopped dead at literally with the COVID. We couldn't give seminars anymore. Nobody was even going outside, as you recall. So we pivoted and started doing them online. And this was my Zoomside chat after FDR's famous fireside chats. This is our Zoomside chat where we discuss various estate planning topics. So thank you for joining. I'm glad you're here, and I look forward to giving you this presentation called The 5 Steps to an Elder Law Estate Plan. This is a picture of the staff. As you can see, my lovely wife and law partner facing you is to your left, Suzanne, and a number of other attorneys and paralegal staff. Our practice is limited to trusts and estates, wills and probate, tax saving strategies, and Medicaid. We have offices in Nassau, Suffolk. In Nassau, we're in Rockville Center, where I happen to be today, and Lake Success. In Suffolk, we have 3 offices. We're in Huntington, Melville, and Islandia. Staten Island, the 1 office on South Avenue, Westchester, 140 Grand Street in White Plains, Rockland County in New City, Orange County in Middletown. Dutchess, we have Fishkill and Rhinebeck, and Albany right there on Wolf Road. So let's get started. And I see we have a nice group with us today. I believe you can answer, you can have post questions. And if you post questions, I'm going to answer them all at the end. And I'm going to answer also some select questions that were sent in ahead of time. And I thank you for those. So what are the major issues facing seniors today? Well, avoiding probate court proceedings on death is a big one. Nobody wants their family tied up in court for what could be months and sometimes years, unable to get access to the assets or sell the home or reorganize the stock portfolio. I lead off with this because a number of years ago, we go back to 1991, the founding of Ettinger Law Firm, 35 years ago, and unknown to most, if not all of you, I was a litigation attorney already for more than 10 years when I heard for the first time back in 1990, late 1990, that if you set up a trust, you don't have to go to court to settle. Well, believe me, after being in court for the last 10 years, I thought anything that keeps you out of court is going to be valuable. I looked into it, and I thought it was a great thing. I still do. And I quit my litigation practice. I founded Ettinger Law Firm to keep people out of court. Because when you go to court, who's in charge? The judge, right? Now, when the judge says jump, your answer has to be what? You're thinking how high, but it's actually how high, Your Honor. You have no control over what's going on in court. You don't know how much it's going to cost. You don't know how long it's going to take. It's not a happy situation. So everybody wants to avoid court proceedings. And we can do that with the living trust and making assets joint and beneficiary. We want to avoid the multiple probate problem, which occurs if you own property here, and let's say Virginia, you have to probate the will in New York and Virginia. So it's going to take twice as long. And you can't start Virginia until you finish New York. So it's a very time-consuming and expensive process. If you set up a trust, we put New York and Virginia or whatever other state it is into the trust to avoid the 2 probates. We want to seriously avoid having a legal guardian in the event of disability, because if you don't have an adequate plan and it goes to court to appoint a legal guardian, you have no idea who they're going to pick. It could be anybody. It's up to the judge. And might even be a complete stranger, often is, actually. We want to avoid New York and federal estate taxes. Not a problem for most of us. The New York exemption is over 7 million. I think it's 7,160,000 to be exact. The federal is 13,990,000. Most people are not going to have a problem. Certainly with the federal, some people may be over New York. If you are, I'll talk a little bit about it at the end of the presentation. We want to protect our assets from long-term care costs because too many people lose their home and life savings paying for long-term care. And we want to keep the inheritance in the bloodline and protect that inheritance if the children get divorced or sued. So these are the major issues facing seniors today, and we're going to address them in this presentation. So what are the 5 steps to having an adequate elder law estate plan? The first one actually is the social, and the social is more important than the legal. The legal is, or should be, I'll say, should be designed to serve the social. Too often it's not. Too many plans are perfectly legal, but they break up the family because the social work wasn't done first. Here at Ettinger Law Firm, we believe in doing the social work first and the legal work second. So if you're going to have an effective plan, you have to know that family and what they're about. That's why we try to make it very relaxed here in the office, make it comfortable, so you feel like you're talking to a friendly person and you can open up. It's a safe environment, judgment-free zone where you can open up and say what you want to say about your family and your family relationships and the dynamics. So obviously, do you have children? How's your relationship with them? Each one. What kind of work do they do? Do they get along with each other? Are they married? How do you feel about their spouses? You know, very often when the clients, I say, well, do you like your son-in-law or daughter-in-law? You know, sometimes they're surprised I ask the question, but it makes a difference. Sometimes people have a son or daughter who's controlled by their spouse. I have to know that to do an effective estate plan. There's options there that you want to be aware of. So these are obviously very important issues. Do they have children? And were the children theirs or from this marriage or previous marriage? What about the second spouse? Does he or she have children from previous marriage? All this goes into making sure your assets go to your grandchildren and not somebody else's grandchildren. What kind of work do they do? That's important because obviously if they're in the medical field, they might be have the inside track on being your healthcare agent, healthcare proxy. If they're in finance or business or law, they might be a good candidate to handle your affairs if you become disabled and after you die. This tells me if they're in a family business, and we have to address that. How do we deal with the family business? Maybe we give it to the one who works in the family business and we compensate the other children with other assets. You know, I've had a lot of clients over the years tell me they want to leave the family business 2 ways, 3 ways, but only one of the children works in the family business. I say, well, nobody wants to work the rest of their lives for somebody else. You know, that's not going to really, it doesn't work socially. It might work legally, but it doesn't work very well socially. So we look at alternatives so that the one working in the business actually gets the business wherever possible. Where do they live? Obviously, for medical decisions, proximity is helpful, but it's not, you know, it's not it doesn't prohibit picking somebody from out of state because, you know, we have Zoom and all these things. But certainly to handle your legal and financial affairs, it helps if they're close by. If nobody's close by, then we make do. Okay, so we now have the family dynamic. You know, this could take a short amount of time. It could take a lengthy amount of time. Some families have a lot of dysfunction, a lot of problems, but we don't give short shrift to the family dynamic. We're going to spend as much time as we need getting to know you and your family until we have it all fleshed out. And sometimes there's, you know, significant time spent on that and back and forth because it's the essence of the plan that it works socially, and it doesn't break the family apart, but hopefully it brings them together. Step two, let's look and see what you have now. Do you have a will, a trust, power of attorney, health proxy, and living will? Bring them in. We're going to look them over. And the first thing we're looking at, are they legally sufficient? Often they aren't because they weren't handled or prepared by an elder law firm. And that's because many times the client did them years ago before they were older adults. Just so you know, we don't use the term seniors anymore. It's an outdated term. We refer to our clients as older adults. And that encompasses obviously a broad range. But if there are defects in your trust, power of attorney, health proxy, we explain to you what they are. It's just plain English. For example, the power of attorney may not have a gifting power to allow your agents to move money out of your name if you become disabled. The health proxy often omits the cell phone number of the agent. In an emergency, we can't be writing them a letter. It's not going to work. We have to get them on the phone. So, and then the power of attorney, very often it says, my husband first or wife, and my children second. Well, we frown on that here at Ettinger Law Firm because if you name your spouse first and your daughter second, your daughter can't use it unless she can prove her mom can't. And that's hard. You have to get a letter from a doctor. Will the doctor write the letter? Will the letter be clear and unequivocal? Can you get the third party to accept the letter? We like to say mom or daughter because we're not worried about daughter taking advantage. We're more worried about her having the ability to use it as if and when she needs it. So we're going to look, not only are they legally sufficient, are they practically sufficient? Are they going to work when you need them? Is the right people going to be in charge and have the powers they need? Do these documents you have reflect your current wishes? Are these the people you want in charge for legal, medical, financial? Is this the way you want your estate to go? Are you a U.S. citizen? Obviously impinges on estate planning. There's rules for non-citizens. Non-residents, green card is covered by U.S. rules. Do you expect to receive an inheritance? The plan could be quite different depending on how much you might receive and when you receive it, might even push you into a taxable estate. We certainly want to know about that. Do you have long-term care insurance? And if you do, what's the daily benefit and the duration? Is it for 3 years, 5 years, lifetime? So we're going to look at any long-term care insurance you have. We're going to look at your income, which continues if you become disabled. Social Security, pension, interest, dividends, RMDs on your retirement, required minimum distributions. The acronym is RMD on your retirement plans. And we look at the benefit plus your income and see, does that cover the cost of care? If you don't have long-term care insurance, then we're just going to obviously look at your income and see if that covers the cost of care at home or in a facility and see if we need to come in with asset protection strategies. Step 3, reviewing the client's assets. So a lot of times people will come in without the form filled out. And, I try to be gracious about it. You're here. Thank you for coming. We talk. But understand that the estate plan is quite dependent on the assets. Different plans for different assets, the size of the assets, but also the quality of the assets. How are they titled? How much are they worth? Are they joint? Do they have beneficiaries? Are they retirement accounts or non-retirement accounts? Quite different issues. For example, retirement accounts are exempt from Medicaid. They're also exempt from probate. They have a designated beneficiary. But I may want to change those beneficiaries to leave it to inheritance protection trust for the children. The inheritance protection trust protects the inheritance if the children get divorced or sued. When they die, it passes by blood to your grandchildren instead of to the daughter-in-law or son-in-law and their families. So we're going to want to address IRAs, 401ks and the like by beneficiary designation, perhaps naming your or the children's trust as beneficiaries. Other assets are exposed to the cost of care. We're going to look at protecting those from long-term care. to qualify you for either home care, help with washing, dressing, showering, etc., or facility long-term care. So if they're not qualified, they're non-qualified. So non-qualified assets are exposed to the cost of care. We want to know, are they joint? Do they have beneficiaries? Now, some people think, well, I have beneficiaries on everything. I have an estate plan. Well, not exactly, because just having beneficiaries doesn't protect the assets in long-term care, doesn't protect the inheritance if the children get divorced or sued, doesn't keep it in the bloodline for your grandchildren. So having names on everything just avoids probate, but it's not a complete estate plan, far from it. Step 4, now we're in a position to develop the elder law estate plan. So who do you want to make medical decisions for you? You can only name one person at a time. Why is that? Because if you name 2 people and they didn't agree, the doctor wouldn't know what to do. So you can only name one person. If that person is unable to act, then the second person is unable to act, you can name a third person. But name, address, and cell phone number. Okay, we give you at least 6 copies of that. Give one to your doctor, and you take one with you every time you go to a medical facility, at least if you're checking in, because they don't keep it on file. So just because you were there last year doesn't mean they have it anymore. They don't know if you change your mind to pick somebody else. So you always have to bring one with you when you're checking into the hospital. Now, who do we want to handle our legal and financial affairs? Should be one person, more than one person. Should they act together or should they be able to act independently? I can tell you now, we're very, very strongly in favor of your agents being able to act independently. So they have to keep each other informed, but it's very impractical to name 2 agents that have to act together because banks will not permit them to open an account that requires 2 signatures. So right away you have a problem. So type of thing we'll talk about in the office. You know, let's say you have 3 children. Again, I talk about the social. If you have 3 children, it's a bit of a dilemma because 3 is too many trustees. But if you pick, although it's happened, I will do it if you insist on it. And that's your family dynamic, especially if they're all in the area. But 3 is a lot. But then again, if you pick 2, you're leaving one out. So I usually prefer, if you have 3 children, to pick one and the other 2 back up together. But there's exceptions to every rule, and your family dynamic may be different. Now, next question. Do you need a trust or a will? Now, we do wills. Some people do a will because they have 2 names on everything and they don't have a taxable estate. They might have a young family. They need something in case they both die because if 2 names are on everything and one dies, it automatically goes to the other. So, in the very, very unlikely event of a plane crash or something terrible, a fatal car accident where both parents die, yeah, they need a will to make sure that it goes to the kids and it's somebody's in charge until they're a certain age and can use the money for their health, education, maintenance, and support. But for these clients, a will is going to be better than a trust because the trust is more expensive and the value is not there for them. But for our clients, generally, the most of them are, 60 plus, they're going to be better served by a trust because a trust takes effect while you're living, which is why it's called a living trust, and it has a plan for disability. As you get older, you need a plan for disability as well as for death because the rate of disability eventually is half of all people will have a period where they can't handle their affairs. So generally, older, we're looking at a trust, not alone. It comes with power of attorney, health proxy, living will. And you get something called a POUR, P-O-U-R, pour over will with a trust, which does 2 things. By law, the later will cancels the earlier will. And it also says, in case I left something out of my trust, pour it in there after I'm gone. Really, it's just in case, because if it's not in the trust, we're going to take steps to make sure that it has a beneficiary, it's joint with somebody. but something could always be overlooked unintentionally. So we have the pour over will just in case. So if we're looking at a trust, should be revocable or irrevocable. Well, revocable trusts, you're in charge. If there's two of you, you're both in charge. As I said, it can act independently like a joint account. Buy, sell, trade, spend, take anything out, put it in, change who's in charge, who you leave it to. Very, very flexible, and you're in charge. Avoids probate and has a plan for who takes over if you become disabled, which avoids guardianship proceedings. So revocable trust is for those who already have adequate long-term care insurance together with their income is enough to pay for the cost of care, or they have no concern about that, their family is going to take care of them, or perhaps they're going to have already purchased into a life care community that includes nursing home on the premises, like Jefferson Ferry we have here on Long Island. They're all over the state, a number of them. They're called CCRCs, Continuing Care Retirement Communities. You can look for one in your area. It includes, you buy in, you could be independent living, you can have assisted living, and you could have long-term care all in the same campus. But for many people, they either cannot get long-term care insurance for medical reasons, they cannot afford long-term care insurance, they've dropped the long-term care insurance because they keep jacking up the premiums, or the long-term care insurance they have is just not adequate and not in a position to buy more because of age or economics. So we do quite a few irrevocable trusts every year, been doing them for a long time. And it's called the Medicaid Asset Protection Trust, the MAPT, and it qualifies you for care at home or in a facility. There's no look back yet for home care. They've been talking about it for years, making a 2.5-year look back. They just keep kicking that can down the road. Who knows if it'll ever happen? We'll keep you posted. But there is a 5-year look back for facility care. It's not an all or nothing rule. Let's say you set up the trust. 4 years later, you have to go into a nursing home. You only have to pay for the 1 year that's left. And don't be afraid of the word irrevocable. In New York, you can revoke an irrevocable trust. How is that? Well, it's irrevocable because you folks, the ones who set it up, you cannot revoke it yourself. So the law says, so far as you're concerned, that's an irrevocable trust. But we have another rule on the books in New York that says, if every person named in the irrevocable trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties. So you and the kids sign. But it's even better than that, because let's say one of the kids won't sign. We can still revoke it, because what you've cleverly done is in that irrevocable trust, the Medicaid Asset Protection Trust, you reserve the right to change the trustee, and you reserve the right to change who you leave it to. One of the kids won't sign to undo it, and you want to undo it. You say, okay, well, I'm taking you out as trustee. I'm taking you out as beneficiary, as is my right. You're no longer a party to the trust, so you don't have to sign. I'm undoing it without you, which is all to say that you have complete control over the irrevocable trust. There's so much misinformation about these trusts that I like to say sometimes when it comes to elder law estate planning, there's more misinformation than information. So we'll see later. I published my third book on this subject. It's out in the public domain. It's on Amazon. We give you a free copy when you come to the office. Everybody has scrutinized it. There's no mistakes in those books. So you can read those and get correct information. You can also download it right on the website, trustlaw.com. Same website, ettingerplan.com. Next thing, in developing the estate plan, how do you want the estate distributed? All at once or over time? I'm going to talk about, some of your options when you come in. Here's one formula that I learned many years ago. Give them 20% when I die, half of what's left after 5 years, the remainder after 10 years. The theory there is they'll get to 20%, they'll blow it. They're going to have to wait 5 years before they get the next 50%. And finally, 10 years later, when they have some smarts, hopefully, half the estate is still left. So, you can pick any age, you can pick any distribution. You could put somebody else in charge of their share and handle it for them. The possibilities are endless. That's why we want to flesh out the social to see, do we need a trust for that person? Who should be in charge of it? What should the terms of the trust be? This is for people who are not good at handling money or have constraints like they could have substance abuse, they could have a spouse that controls them, they could be learning disabled, special needs, all kinds of issues. Or they could just be a spendthrift, they can't hold on to anything. So in this case, we have a lot of options to make you feel comfortable and secure that this will be managed well. Let's talk about estate planning for larger estates. So on a roughly $7 million estate, this is the New York State estate tax, not the federal. Family owe over 600,000 estate taxes. Ouch. I mean, maybe nobody's listening over 7 million, so it's only one slide. Bear with me. If you have a spouse and you set up 2 trusts, you can double the exemption past 14 million tax free. So tax savings start at 600, go up to over $1 million, depending on the size of your estate. Maybe it doesn't apply to anybody, but I like to mention it. Step 5, executing and maintaining the plan. Now, a lot of firms can set up a plan, but executing it and maintaining it is what separates the wheat from the chaff. So our preference, we don't like to send out drafts at Ettinger Law Firm because not all language is perfectly understandable, and we don't want people to get stress and anxiety. We like you to come in where we can review the documents, explain it to you, and answer your questions. You can get them ahead of time, but we prefer you wait for the meeting with us. We're going to give you instructions on changing the beneficiaries or IRS 401ks. Often we'll do it for you. You bring in the form, we fill it out. Give us the name of your financial advisor, we send them instructions. But remember, on the retirement accounts, you may want to make the Children's Inheritance Protection Trust the beneficiary. Remember, the Inheritance Protection Trust protects what you leave. The children get divorced or sued, and it passes by blood because of the trust of your grandchildren. Without the trust, it would go to your in-laws and their families. I publish a weekly law letter, advises you of any law changes and other issues. We call you in for a free review every 3 years. Okay, so we will assist you. Let's go back. Well, we're going to assist you in getting all the assets into the trust. We'll prepare all the deeds. We'll send letters to your emails to your financial advisors, and take it from there. I have a monthly webinar which explains all of estate planning, called 4 Advantages of Using Trust. This is the same seminar I have given for over 30 years. It's comprehensive. You can log on to ettingerplan.com and book in for, it's in the evening for an hour. I do once a month, so July 9th or August 6th. I think you might find that quite useful. Even if you can't make it, if you register, you get the recording, so you can watch at your leisure. Now let's talk about the unique planning process at Ettinger Law Firm. There's a copy of my book, 2025 edition, right up to date, Ettinger Law Firm's Guide to Protecting Your Future, my 3rd book on this subject. So the process has already begun with this seminar because you're warmed up to some extent. We offer you a free initial consultation where we do a free review of your existing plan if you have one, which I mentioned earlier, how we scrutinize it. You'll get a free copy of my book, and we'll advise you which chapters apply to your situation. Right in the first meeting, we get a good handle on your situation. Almost always we can tell you how much it'll cost. You know what you're in for. We always have a second free follow-up consultation to have your questions answered. So, in that first meeting, we gave you a copy of the book. I might ask you to watch one of my videos as well. and it'll be with me or one of the other, a number of lawyers we have here, 8 lawyers, all qualified and trained properly, in my view. So with that second meeting, we're going to answer any questions about what you read, any thoughts you had from the first meeting. We're going to draft the estate plan, and we'll give you well, drafting the estate plan means, you know, who's going to be in charge for medical, who's going to be charged for legal and financial, how's the estate going to be distributed all at once or over time, that sort of thing. And they'll give you a detailed 3-page written proposal. It's the same fees we mentioned the first time, but now it's in writing, so you have it all on paper. And now the choice to go ahead is yours, of course. And this is unique to Ettinger Law Firm. Unknown in the legal profession, we do not have a retainer agreement. We actually give you a fee proposal. Our proposal says we're going to do all this work on your say-so. There's no fee until after everything is signed. So why don't we take a retainer? Well, I've often said estate planning is all about taking back control. So you're taking back control from the courts and government, giving it to yourselves and your loved ones. Well, after a few years of putting on the seminar, I realized that while I'm talking about taking back control, the first thing that a lawyer does when a client comes in is they take a retainer. And with the retainer, what does the client have? When you gave the lawyer the half up front, what do you have? You have nothing. You have a promise that the lawyer is going to perform. What you actually have is a loss of control. Now you've paid money and you have to hope the other side performs and performs to your satisfaction. So I thought, well, it doesn't make sense for me to keep talking about taking back control from the courts and government. And the first thing that we do when a client comes in is we take the control away from them. So I thought, you know, wouldn't it make more sense for us to do the work and the client plays at the end after they're satisfied? Because now the client's in control the whole time. Now, if we're here to serve you, and that's best for you, then we feel it's best for us. And, you know, it has worked very, very well because it's more than 10 years now we've been doing this. And we only have happy clients, which is a nice place to be. So we have that final meeting, review and sign documents. Okay. We take credit cards, but there's a 3%, so people don't like it anymore. So most people pay by check. But you have a choice. You can pay all at once, or you could do three monthly installments, a third when you sign, third after a month, third after 2 months. Now, after the signed documents, we don't say goodbye, we say welcome to the firm. Now, the standard in New York is thank you very much, goodbye. In fact, the bar advises the estate planning lawyer, when the estate plan is concluded, to send you a letter thanking you for your patronage and advising you that this concludes our representation of you in this matter. And they do that, they advise lawyers to do that because if you made a mistake, they can't sue you after a few years. How do you like that? So we're not worried about that. The bar and lawyers, the way they're trained, they're concerned about the 1 in 10,000 clients that's going to sue them. We here at Ettinger Law Firm, on the other hand, are more concerned with the 9,999 clients that aren't going to sue us. So we don't say goodbye. We say welcome to the firm. We keep you up to date of law changes and other matters with our weekly Ettinger Elder Alert. We don't charge for phone calls or emails. And we give you a free review of your plan every 3 years. We call you in. Any change in your health, your assets, your family. This way, oh, there we go. No charge for phone calls, emails, or questions. But with our program, your plan is never more than 3 years old. And it's designed to work when you need it, not when you signed it, I hope, many, many decades before. So this has been very effective. And, you know, it's nice. We build a relationship with you, and we grow together. If you'd like a free consultation with myself or my law partner and wife, Suzanne, she runs Islandia and Melville. I'm generally in Lake Success, Rockville Center, and I go to White Plains. once a week. I go to Staten Island every other week. So it could be with me or any of them. These are available in office, by Zoom or by phone. Make no mistake, because it's a social exercise, in office is going to give you the best result. But for various reasons, Zoom or by phone is acceptable. And sometimes we'll do a Zoom first and then an in-office meeting second, or a couple of Zooms and then an in-office meeting. Whatever works. Not everybody can get out. People have issues, so we understand. Just call our 800 number, and it'll prompt you to make the appointment, or go to the website and you can, the schedule is there. You can book yourself right in. Okay, so